In January 2026, significant changes are expected in the U.S. marriage-based green card process. These updates will directly impact how spouses and families can navigate the path to permanent residency. The rules governing immigration and the green card process are evolving, with an increased focus on verification, interviews, and evidence of a legitimate marriage. This video will break down everything you need to know about the new rules and how they will affect you whether you're newly married, in the middle of your green card process, or planning to start the application. From stricter documentary requirements to potential changes in visa priority dates, we'll walk through the details that could change the way you approach the process in 2026. A married couple with documents and USCIS forms at the kitchen table, representing the green card application process. A marriage green card allows a foreign-born spouse of a U.S. citizen or permanent resident to live and work in the United States. The process involves several steps, including proving the authenticity of the marriage and undergoing background checks. The new rules in 2026 reflect the growing concerns around immigration fraud and the need for stronger documentation to demonstrate the legitimacy of the relationship. This is why understanding the new requirements is crucial to avoid unnecessary delays or denials. An image showing USCIS forms with highlighted text demanding proof of marriage authenticity, including joint bank accounts, shared assets, and joint travel plans. Under the new guidelines for January 2026, applicants will be required to provide more evidence than ever to prove that their marriage is bona fide, meaning it is not entered into for the sole purpose of obtaining immigration benefits. This includes proof of joint travel photos of the couple together at events, correspondence, and family interactions with in-laws. In addition to standard documents, USCIS may also request affidavits from family and friends who can attest to the relationship. The heightened scrutiny means that spouses applying for a marriage-based green card will need to ensure they have a complete, well-documented case. USCIS officers performing background checks and security screenings on applicants, with a focus on ensuring fraud prevention and immigration integrity. One of the significant changes to the marriage green card process in 2026 is the expansion of background checks. In addition to the usual criminal background check, immigration violations, and previous visa status, USCIS will also vet applicants for any connections to terrorist groups, organized crime, or fraudulent immigration activity. The new rules come as part of the U.S. government's effort to combat fraud and strengthen security measures across the immigration system. This will likely result in longer processing times for green card applications, but will help ensure that only legitimate and qualified individuals receive approval. Two individuals sitting in front of USCIS officers during an interview, nervously answering questions about their relationship. One of the most talked about changes in the marriage-based green card process is the mandatory interview. While interviews were previously required in some cases, they are now a requirement for everyone applying through marriage. This change is expected to take effect in 2026 for both spouse-based green cards and conditional resident statuses. The USCIS interview will likely focus on confirming the authenticity of the marriage, including detailed questions about the couple's relationship, family history, and shared experiences. Be prepared for questions like, how did you meet? Who proposed? And how did the proposal happen? Have you visited each other's families? What are your future plans together? In some cases, the interview could also include a review of your shared assets, such as joint insurance policies or property ownership. An individual entering a U.S. consulate for consular processing. While a couple in the U.S. is working on their adjustment of status paperwork, under the new rules, there will be more emphasis on adjustment of status, AOS, for applicants already in the U.S., especially those who entered on a non-immigrant visa. If you're currently living in the U.S. and applying for a green card, you may be able to adjust your status without having to leave the country. However, you'll still need to undergo a lengthy application process and provide substantial evidence that you've maintained lawful status. For those who are applying from abroad, consular processing will still be the route to go, which involves interviewing at a U.S. consulate in your home country. A close-up of a visa bulletin showing the priority dates for family-based green cards, highlighting the changes in availability for spouse-based applications. The visa bulletin will play a more significant role in determining when spouses can actually apply for a green card. the priority dates for family-based green cards will likely shift, creating a longer waiting period for individuals in countries with high immigration demand. Backlogs could continue for countries like Mexico, India, and the Philippines, where the wait time for marriage-based green cards may extend for several years. Applicants will need to monitor the visa bulletin regularly and work with their immigration attorneys to ensure they're applying at the correct time to avoid delays. A family sitting together, looking at immigration forms and discussing their green card process. For spouses and families, the new rules require a higher level of preparation and documentation. Not only will applicants need to demonstrate the genuineness of their marriage, but they'll also need to stay on top of the ever-evolving rules and processing times. This might mean staying in close contact with an immigration attorney to guide them through the process and ensure they're meeting all the updated requirements. Families should also be prepared for potential delays, as the USCIS is expected to process applications more thoroughly, and waiting times could extend. However, it's important to note that legal permanent residents and U.S. citizens are still eligible to sponsor their spouses regardless of where they're from, with some families potentially qualifying for faster processing, a couple reviewing their green card application forms together, double-checking everything to ensure all the necessary documents and evidence are included. Avoiding common mistakes in your marriage green card application is crucial, especially as the new rules come into play. Some of the common mistakes include missing documentation. Make sure all forms and evidence are complete, including tax returns, joint property documents, and proof of shared financial responsibilities. Incorrect information. Don't forget to update your address and contact information, and make sure your forms match your personal history. Missing deadlines. Timely filing of forms is critical. Make sure you know the priority dates and avoid waiting too long to apply. Working with an experienced immigration attorney can help ensure that you avoid these mistakes and ensure a smoother process.